switch conversations on hard facts on 92.3 Nigeria Info. Once again, I am Kalada Kurubatwe. Good afternoon to you. It's raining cats and dogs outside the studio. However, we want to have a very hot conversation because it's lingered since on Monday. So on Monday, a judge, Justice Okogbole Basam, gave a pronouncement of court that has become a talking point ever since then. We've seen several reactions. We have seen the River State's government react to that judgment. We've seen different interpretations of that judgment, and now there is what is circulating on several platforms as it relates to the certified true copy of the judgment. It's a 76-page document circulating on several media platforms, social media, different media platforms basically, and I've taken my time to read it. What was reported was contained or is contained in that 76-page copy of judgment. And so I've decided to invite a lawyer. Like I said, we were looking at legal issues. I've decided to invite a lawyer. It's a familiar voice, familiar face as well. I'm talking about the National Legal Advisor for the Committee of Defense of Human Rights. I'm talking about Barrister Ekine. Barrister Ekine, it's good to have you on the show. Welcome and greetings to you.
Kalada, it's my pleasure to join you again this afternoon. So I appreciate it. Thank you very much.
All right. So I sent you that document. Once again, several documents I've really but the signature of the judge is on it, and it is believed that is the true copy of the judgment. And you are the lawyer. You understand the legalese better than I do. But with my limited knowledge of the Nigerian jurisprudence, there were several petitions before the courts and counter addresses to the petitions. And the judge ruled, or should I say, started commenting based on the petition or counter petition on jurisdiction, and agreed it did not have jurisdiction based on the argument of section 27 subsection E. The argument also looked at that. He also touched that as well and said the petitioner did not have any direct what's illegal now. They did not have any direct implication as to how, even if the case was to go down, it didn't directly. And they'll talk about the PP joining the suit, the mind for that, and that was granted as well. There was the talk about remember, if the lawmakers expected or not, that was all taught, and in the resolution, it was that they still members of the PDP. Because the PDP also had their own address. Is it what you guys call counter address? I don't know how it's called. But yet also addressed the court, and in address they said that list of not reading and lawmakers 10 ward meetings of the PDP is an internal argument. Welcome to once in here. All right, let's start. What you understand by the copy you have. Can the court, once again, I've asked this question like a million times this week, can the court do what is done when it says it's not have the jurisdiction to do so?
Well, I've made a copy of the 76-page amendment. Appreciate that. And to also say while it's raining cats and dogs around your area, it's hot here in town. Not even a couple of days.
All right.
So that's for I can. I'm a lawyer by the grace of God. I thank him for right from much. And then the day that that was made in Abuja, and we are given the clear directive that lawyers we hold on principle the rule of law, and to almost always, in fact always, defend Constitution, and then of course associateers. Since Monday, the Honorable Justice Basam Okogbole, let me directly to question asked before I need to tell you, when you read that judgment, you were wondering what I was going to do. I've done for the judgment. So the last part you said, Kalada, if a court has no jurisdiction, whether of the matter before it, whether of the parties, or any consideration, the jurisdiction, what is not linked in terms of number, the elementary effect of law, every proceeding, that's on the part of the parties, or any judgment or declaration or by the judge. The position of law is penalty. A judgment rendered does not adjudicate anything. The judgment, and every lawyer who's this don't expect that bench. But I haven't said so with respect to the judge. Yeah, we'll see what the court says itself. Okay. But on the general poll, you ask the question: what's the effect of any decision court when the court loses jurisdiction? don't have to just so-called generally, any person listening to us now, our esteemed listeners, if a court has no jurisdiction of the subject matter, like I said, jurisdiction could be in different respects, then a judgment rendered therein does not adjudicate anything. It does not bind the parties, nor can it thereafter be made the foundation of any right. It is a mere nullity without life or vigor.
Let me throw a question. Let me throw a question that I believe not lawyers will want to ask as it relates to this matter. So petitions were taken to the court. Prayers were made, right? Is the court not?
Yes, I was going to go into those issues.
Is the court not supposed to answer the prayers, brought before the court? Because, when you look at that, 76-page document, it seemed to tackle every issue that was brought before the court, starting with jurisdiction, locus standi, and the rest. So, could that be what Justice Bassam did with that, answering all of the prayers before the court?
Kalada, I'm a bit hedgy here to probably rush on these issues, but I know that you're moderating. Kalada, I laid the foundation. The reason I laid that foundation, I think, answers the question to the rest of the other proceedings in that court. But let me say again, maybe in prioritizing those issues, okay? And by what I've read and what I've always known, and I know with respect to most of those other matters that were referred, is that the claimants approach the court, in this case, commencing their action by one of the means of commencing an action in the court, which is by way of originating summons, okay? And then they served on the other parties, all of those they listed as defendants. Now, those defendants have a right to respond to that originating summons, and then the affidavit that was filed in support of that, and then the written address by the claimants, counsel to the claimants. That's what you are referring to their responses. Now, you could respond in these ways in an originating summons proceeding. You respond by filing a counter affidavit, that is, objecting or reacting to the affidavit in support of the claimant's originating summons. Or if you are challenging anything, perhaps the jurisdiction of the court or the competence of the suit, then you file a motion or notice or a preliminary objection. That is part of the motions that the court took. So the defendants, in reaction to the claimant's originating summons, they filed the motions challenging the jurisdiction of the court. So you could see that even the issue of challenging the competence of the court was out of the processes filed by the respective defendants. The first, second, third defendants filed the same action or motion challenging the jurisdiction of the court. And you know what? Whenever any party is challenging the jurisdiction of the court, the prayer of that party, including in this suit, the prayers of all of those defendants were that, Mr. George, there is nothing here to hear. Just throw away this matter from the threshold. And when I mean the threshold, from the entry point, from the doorposts. And that is why it is elementary law when we assert that jurisdiction is a threshold matter. It's a threshold issue. It's a foundation issue. It's the beginning. It's at the doorstep. Before you step into the room, the issue of jurisdiction is front burner, it's front line. And it is not fortuitous. I mean, it is not by chance that even the judge himself, when he wanted to entertain all of this, he started by saying he would deal first with the test whether he has the competence, the substantive originating summons. This happens in a matter where competence of the judge is challenged. Even if the judge decided to take aim, that is to say, like it happened now, all of these processes had been filed since in May. The originating summons, the responses for those who even filed counter. Some didn't even file their counter affidavit, but they just filed the motion challenging the competence of the court. Now, the judge decided to order all of this and go and read all the processes and then come back to court, which was what happened on Monday, and then give his understanding of the arguments of the parties and his decision. But it is imperative on the court, which the court did, to consider first whether the court had jurisdiction. And that is where now, as a lawyer, I have my reservations with what happened. Respectfully so to the erudite judge. But as lawyers, we're empowered to also have our dispassionate considerations, especially when the matter has been decided. Now, this is my view. Once, and it's not just my view, that's the position of the law, the foundation I laid earlier. Once that judge, whoever the judge is, considers the issue of jurisdiction and holds, decides by himself that I no get power or I no get the authority to entertain this matter, in my view, that's the end of it. You don't delve into the merit of the substantive matter. Because even if you do, it's in futility. It's a nullity. Meaning that all the brilliance and all the time and all the knowledge of the law you will exhibit there, unfortunately, not my word here, is a mere nullity without life or vigor. That's the effect of anything that happens after the stage of the determination of the motion in the jurisdiction of the court, and you say, I don't have jurisdiction. So you can examine, you can take all the time in examining the arguments of counsel with respect to the preliminary objection or the motion or notice challenging injunction. And what I read through, from about the first page until up to about page 35 or page 30, the judge was dealing with the issue of jurisdiction. And because when you raise some of those issues, the parties that challenged the jurisdiction of the court did so on different grounds. On the ground that the claimants didn't have the local standi, on the ground that the process was an abuse of court, right? On the ground also that the court didn't have the jurisdiction by the provision of section 272 subsection 3. So the court took time, almost in the first 30 pages, to address these issues affecting the jurisdiction of the court. I know I said 2 days ago when this whole discussion started that even if a judgment is 100 pages, it is not everything that the judge says that is part of the judgment per se. A judge and every judgment in default is required to first examine what counsel have advanced in the argument. So even in the first 30 pages, you find out that what the judge actually said on his own may not be more than 3 pages or 2 pages if you put together. So the judge, most of those who were in court and we are reporting some of these things, or people who have read this thing now, isn't about the volume of 76 pages. The judge was taking time to analyze what the different lawyers were saying and what they filed and the authorities and the arguments they made. You will see the instructive part, what I would call the operative part of the judge's consideration of those arguments. It is where you will find on page 15. Page 15, the court simply said that the suit was properly commenced under the originating summons procedure. That was because one of the grounds of the objection of the jurisdiction of the court by the defendants was that the matter ought not to have been commenced by originating summons, meaning that they were supposing that it ought to have been commenced or brought before the court, perhaps by a writ, where parties would have been required to file their pleadings and people go into the witness box to be examined and cross-examined. But the court agreed with the claimants in this case to say, after all the arguments of about 6 to 7 pages, the first 6 to 7 pages or more, but the court simply agreed that the suit was properly commenced.
Okay, let me pause you. We do have a commercial, so I'm going to pause you.
Okay.
We're going to start off from where you've just stopped, and then I'll throw my question at you. I've been trying to throw a question at you, but just stay on the line, please. conversation. We're dissecting Justice Okugbule Gbasam's judgment. Hopefully, we have the original, and so we're looking at some of the things that are written therein, and we are trying to understand yet again for educational purposes, not because we have, for educational purposes, so we can understand what the law really says and what the law stands for. And remember, our conversations should and would align with the Constitution, which is the ground norm. And joining me to have this conversation is the National Legal Advisor for the Committee for the Defense of Human Rights. I'm talking about Barrister Henry Ekine. Barrister, welcome back on the show.
Yes, Kalada, thank you for having me back.
All right, so just before that very long break, you were telling us about you were trying to understand some of the things that the judge touched on. I think we were talking about writ of summons and originating summons and all of that stuff. Yes. But you can continue from where you left off.
Yeah, just like you said, but perhaps part of expounding on the Enlightenment, but there are different modes of commencing actions in court. So without boring our listeners, you may hear of petition, writ of summon, and then perhaps the other processes. But this particular matter was brought under the originating summon procedure. So one of the grounds for the defendants, when they challenged the jurisdiction of the court, they also argued that the action was brought under the wrong procedure, that it ought to be through another procedure, but perceivably perhaps a writ of summon. By what I was saying before we went on the break, that would have been the procedure where you file pleadings and then persons and witnesses will get into the witness box to be examined in chief and cross-examined, and if necessary, re-examined one after another. That's probably the process in court that would take a long time. But this matter was commenced by the originating summons procedure, which is where you rely on affidavit. So the judge gathered all of the processes that were filed by the claimants and then all the motions by the defendants and the counter affidavits and even replied on points of law. So then the court considered all of these. Like I said, once there is an issue that is challenging the jurisdiction, usually the first thing that any court will look at, because you have to first be competent and have the authority. That's what the jurisdiction means. The authority and competence and the power to determine that matter, either having so over the persons that are parties, or having so over the subject matter, or even having the laws providing or creating that court, vesting such power on the court. So when the court looked at this, one of the challenges which I just raised about how the claimants commenced the matter, the court agreed that the claimants commenced the matter appropriately by adopting the originating summons procedure. And I was making the point that you could imagine that arriving at this point, which is just a short thing that the judge said, was at page 15. Meaning that from the first page to page 15, the judge was evaluating the arguments of counsel. There were many counsel. The counsel for the claimants and then the different defense counsel. So the judge evaluated and arrived at that point at page 15. Then it went on. Another.
All right. I think we have network issues now.
Sorry, please. That is whether the parties that came to court, the claimants, whether they had the right to come to court or had any claim against the defendants. And then the court agreed with the defendants that the claimants that came to court did not have the local standard. And that, he said, at page 18. So when the court decided at that point, Kalada, this is very instructive and very important. Once a court agrees to any of the grounds or some of the grounds challenging the jurisdiction of the court, then the court will arrive at the holding that it lacks the jurisdiction to entertain that matter. And once, like I said, a court lacks the jurisdiction to entertain that matter, then of course the court should ordinarily at that stage exit. Because where a court does not have jurisdiction in a matter, its decision, no matter how brilliantly arrived at, even if it became the next other pages, because actually the judgment, by what I see, started from about page 31 to the 76. So even if it was 31 page judgment, it would have gone to a nullity. if you never had the jurisdiction. And the court held just as early at page 18 that the claimants lacked the locus standi. And then, of course, what it means was that the court dismissed that suit on that ground. This is the holding of the court, that the court dismissed the suit on the basis of lack of locus standi as early as at page 18. Then the court went on to consider the other ground of the challenge of the jurisdiction of the court, which, like I said, on the basis of the provision of section 272 sub 3 of the Constitution. And the court at page 20 held that the Federal High Court had exclusive jurisdiction on this subject matter, that this state high court, that is the judge himself, that he didn't have the power and the authority to consider, to entertain and determine the issues that were raised by the claimants in their originating summons. So in totality, Kalada, the court held that it lacked jurisdiction.
Okay. Now, let me pause you now, because there is something I came across. A lawyer sent it to me, Agbaso versus Iwunze, and it says, an excerpt of that says, on whether court can hear objection to jurisdiction and substantive issues together, it is normal for a court, particularly one whose decision is not final in the matter, when faced with the challenge to its jurisdiction, to also discuss and consider the issues in contention on the merit, where the court has opportunity to consider the substantive issues together with the application challenging its jurisdiction. This ingenious practice has come to serve as a very useful legal role in which we would occur if the trial court's decision on jurisdiction is overruled by the appellate court, requiring the case to be heard and determined on its merits. So I don't know if, maybe there's anywhere in our jurisprudence that allows, yes, I don't have jurisdiction, but, maybe I can say a thing or two on issues. And like the court did, it talked about several other things, talked about whether the Federal High Court is the court to look at such matters. He talked about whether they defected, because he explained what section 109 sub G meant, that defection is when you move from a party to another party, that you have to move to another party. And he also entertained the addresses of the PDP, saying that of course these people have not defected. So that's where my confusion is, and I believe a lot of Rivers people are also confused as well.
Kalada, there's no confusion. I said that even from the outset. I said that in practice, that when the claimant files his suits and then the court jurisdiction is activated, whether the court will hold sustaining its jurisdiction or declining jurisdiction will be only when the court would have considered and read through the processes filed. That is in respect to jurisdiction. I have not got into the substantive matter.
Okay.
The authority you referred is in line with what I've just said, and that's what the court did, including the consideration of section 272. They are all within the sphere of the challenge of the jurisdiction of the court. I have said so that there are three grounds, or about these three grounds, on the fact of the procedure for commencement, the locus standi, and then the jurisdiction with respect to the exclusive jurisdiction of the Federal High Court on the subject matter. So I am saying that in totality, until about page 20, Justice Okobule clearly and rightly so held that he did not have the jurisdiction. He concluded that at about that page 20, when he considered the exclusive jurisdiction of the Federal High Court. But the issue here is, the judge decided to now come back to the originating summon that he had dismissed. Get my point here, Kalada, and my dear listeners. I may be wrong, but the point is this. The court had dismissed, like I said, at page 15. At page 18, on the ground that the claimants did not have the locus standi. It struck out. And then again, on page 20, on the ground that he didn't have the jurisdiction to entertain the subject matter, conceding that the Federal High Court had the exclusive jurisdiction, also struck out the matter on that score. This is the word of the judge. He said that the suit was struck out on that score, and that score was with respect to the Federal High Court having exclusive jurisdiction. In my view, a court can end at that point, because getting into the substantive originating summon and considering the substantive matter, you will arrive at one decision or the other. The question is, you may not be precluded from doing so, which of course he has done so. Nobody will sanction the judge for probably exploring and having researched to still be able to advance his own position on those issues he went further to discuss. But the fundamental question is, what is the effect? And this is what is more instructive, especially to those in Rivers State, the way it turned out on Monday, immediately the judgment was entered. And the way people give the interpretation as if it was enforceable, as if some persons can now go and assume certain positions.
Okay.
That, for me, is the instructive part for lawyers to speak to. What is the effect? Assuming, without considering, that my very respected Honorable Justice Okogbule Gbasam considered, and I think that was quite a light. I have a lot that I've learned from it. I will keep this judgment. It may be instructive, maybe very important and useful to me on some of the arguments of learned senior counsel. There were about three essays in that matter. Their knowledge cannot be wasted. It will be valuable to those of us who are practicing law. But the fundamental question is, where does this go to? And I have given the answer that it does not matter the brilliance. It does not matter the extensive research, and even the very accurate positions that were held by the court. But the fact that the court had held earlier, like I referred specifically to page 18 and 20, and conclusively at the end of it, that the suit lacked merit and the claimants, right, their claims lacked merit and was dismissed. It meant, in effect, that even all of those findings are to nullity, except to the best of our use as knowledge.
All right. Okay.
Deep knowledge of the law.
But
no doubt about that.
If it goes to the Court of Appeal, will the Court of Appeal touch on some of these, judgments? Can I call it that by Okogbule?
No, I doubt. I don't think so, because the position I've just stated there is a position of the Supreme Court. The Supreme Court are held to that effect. You can't do really nothing. What would you do with it? There is nothing you can do with the judgment. It's not binding. It cannot even be enforced. So you can't even. What are you going to the Court of Appeal to do really is when you're dissatisfied with the judgment of a trial court and you seek to have it overturned. And now, who possibly in this case that could even go to the Court of Appeal will be the claimants to say no, that they are probably their matter where their arguments could be that the State High Court had the jurisdiction. That is dissatisfied with the holding of Justice Okogbule, and then they may also challenge that in fact they had the local standard, because they argued that extensively that they had the local standard. They are the ones to go to court. For the defendants, it is similarly in their favor, because they actually wanted the court to throw away the matter from the outset. For them, it wasn't even about an argument as to whether the 26 plus the first defendant and the other 26 persons were still members of the PDP or were still members of the Rivers State House of Assembly. In their own case, that look, there is no matter here even to be heard. And I tell you, I've also been in court where one of these matters was going on, and that was been the argument of one of the senior advocates. He was actually even asking the judge, is this matter still here? That in some other courts that the matter is being thrown away. So why is this one still here? In fact, some of them did not even file their counter affidavit. They only filed the motion challenging the jurisdiction of the court, meaning that they are not even saying that the matter should survive beyond the point of the court holding that the court didn't have jurisdiction and to strike it out. Because the only reasonable and appropriate order to make when a court holds that it lacks jurisdiction is to strike out.
Okay. Yet again, I was trying to make reference to a court case, but I'm having network issues. If maybe I can, I would. But yet again, it has to do with Sir Jude Agbaso versus Honorable Simeon Iwunze and others in the Court of Appeal of Nigeria on Thursday, the 20th day of November 2014. And I think it had to do with the issues for determination, the principle that an issue for determination must flow from a ground of appeal. I think I'm trying to read it, but I don't have access to that court ruling. But if I do, maybe I'll bring it up for a conversation another day. But you're saying that yes, he may have brought up some brilliant interpretations of the Constitution as relates to the prayers before the court, but all of it is a nullity because he had already conceived that he did not have jurisdiction. That's what I've gleaned from the show. Correct me if I'm wrong.
Yes, absolutely. I said so. I summarized by saying that the court himself said the suit was dismissed. He said that at page 18 for lack of local standard by the claimants. It went further summarily to say the suit was struck out, and it did so at page 20 for lack of jurisdiction by the court, considering the provision of section 272 sub 3 of the Constitution. That's excellent. That's the finding of the court. And those are going to be the reasonable grounds if the claimants feel dissatisfied to approach the Court of Appeal, the Superior Court, to the trial court.
Okay.
But now, the question again for me is, I indicated 3 question marks. How and why did the court get into delivering judgment on the merit, on the originating summon, that it has been held to be an abuse of process? Meaning that the court held that even the originating summon was an abuse of court process, and that the claimants lacked the local standard to even institute this action. Then the court went further, however. Like I said, this judge could be a researching judge and wants to also deepen the knowledge of the law for those of us who are learning, and then also to have an opportunity to canvass his own position with respect to those issues that were raised. Nonetheless, that the originating summon was already determined to be an abuse of court process and dismissed.
But Barrister, let me pause you, sorry, because there is a confusion. Yes. Now, you've just said, and because you're a lawyer, maybe you can interpret it and understand it, but you see, in as much as we may agree with the argument that it is a nullity once he says, he does not have jurisdiction, however, he still ruled on the merits of the case, which is part of the court document, and I don't know how it is done, but it is very possible that the people who are favored by the ruling on merit of the case may take that as a judgment, which we have seen no,
they can't. They are lawyers, they know. Kalada, I won't allow you to land on that. The learned senior advocates of Nigeria and even all the other lawyers that are in the matter, some of these conversations we are having are basically arguments that are coming from non-lawyers with respect to them. I am not sure that even the counsel that were there in court for the defendants will go celebrate and then think that they can give effect to those other submissions, or if you like, the holdings of the court from about page 31 to 76, and particularly at between pages 65 to 76 of the judgment, where the court deeply actually, at the end of consideration of those issues, where the court raised those issues of defection, and that was excellent. Like I said, I keep saying that. Great knowledge for me, maybe appropriate for another matter. What defection meant, and then how to prove membership of a member of a political party, and all of those issues. Those are critical issues that were on the merit on the originating summons, and probably even the counter affidavit of the defendants. But by the fact that the matter, I keep saying this, the court held that the suit was not competent, and then the claimants that brought the suit lacked the power to bring it, and of course that he didn't have the jurisdiction to even entertain the matter. Like I said, jurisdiction is a threshold matter, it's the beginning point. So when you hold, if I don't want to over-label myself, once I hold I don't have jurisdiction, I close the book into 3-page ruling. A ruling on jurisdiction can actually end at that very early stage of the 2, 3, 4, 5, 6, 10 pages that the case may be. Right, but it's excellent that we went further.
Barrister Henry, let me pause you. Sorry, I've got questions, please. Now, you're saying that it stops at page 18 where, the jurisdiction matter was touched, but the court made a pronouncement.
Page 20.
Okay, page 20. For instance, the court said that the laws made by defendants 1, 2, and 3 are laws that should be obeyed by defendant 1, 2 are laws that should be obeyed by defendant 3. It's a pronouncement of law. It
cannot be enforced. Kalada, I've said that repeatedly. On this judgment, it can be enforced on another. It cannot be enforced at this. It can't play hot and cold in law. It cannot be enforced by this judgment that the court itself has declined jurisdiction from the beginning. That's the confusion about this matter. That's the foundation of the law.
So you think the matter should go to the Court of Appeal then?
It's not about going to the Court of Appeal. I believe that even the judge himself and even the counsel to the defendants knew, like I said, a lot could be in a judgment. A judge also teaches. A judge also expounds the law. And a judge will have an opportunity to even advance his own knowledge of the law, either in writing, in journals, or presenting lectures, or in his judgment. It is not out of place. It cannot be ruled out completely that those pages from about page 31 to 76 should be excised from the judgment. It's there, but the fact is, that's why you saw when the enrolled order came out, and people in the beginning, some were thinking that it's different from what is excellent, that I've read the judgment and the enrolled order. The orders are the part of a judgment that can be enforced. That's one thing. People, and including lawyers, we should be able to distinguish between the full judgment and then the enrolled orders. That's the part of the judgment that can be enforced, that the judge declared and made certain orders. Even if the judge said here, particularly when he was rounding off, and said, I hold that the claimants failed to, clearly, that the claimants failed to prove that the first defendant and 26 others are now members of the APC. They are still members of the People's Democratic Party and members of the Rivers State House of Assembly. He said this between pages 75 and 76. The last page concluding. It, however, because can't be enforced, can't be part of the enrolled order of the court. That enrolled order was also signed by the judge.
Okay.
If it was the judge that delivered the judgment and he knew that the enrolled order wasn't going to be part of that, there's no confusion really anywhere.
All right, then.
The law is interested, and I'm glad that I'm one of them.
All right, then. I'm sorry, you and your jurisdiction are confusing us Rivers people and deeply in the fight. But we will still push this conversation forward. But at this point, we'll have to step on the brakes. And thank you very much. But just to ask, do you think the judiciary is heightening this crisis? Yes or no? Is a yes or no answer, because I don't have time.
It's a yes. It's a yes. It's a yes. It's a yes. There's a way. If we employ judicial activism, we would have ended a lot of these things by being very pragmatic and frontal on this issue.
All right. Thank you very much, Barrister Ekine. I've got to go, but thank you very much for your time and your arguments then.
Thank you very much for having me.
All right. A commercial break, and after that, the news at 6. Just stay tuned.